the mandate of the Ministry of Lands, Housing and Urban Development to ensure a rational, sustainable, and effective use and management of land and orderly development of urban and rural areas, as well as safe, planned, and adequate housing for social, economic development. Despite government's effort through enacting laws and regulations to regulate and harmonize the relationship between landlords and tenants, the ministry continues to receive reports on illegal eviction and use of forged documents, especially court orders, to disrupt and dislodge tenants by occupancy. The ministry has recorded a number of cases in respect to double titling, family issues relating to succession, landlord-tenant issues, double sales by registered proprietors, generational claims, boundary disputes, illegal grants by the district land boards, and issuance of titles in error. The Office of Titles has registered 2,134 cases where it is required to give evidence to courts of law, all for reasons to implementing the court decisions from 2014 up to date. I therefore would like to remind Ugandans that the Land Act 1998 as amended has provisions that protect tenants from evictions and restore a harmonious relationship between a landlord and a tenant. To another one, it is also an empty talk. Anybody who occupied land by the legal vivanja owners or the bona fide ones buys more or less. Corrupt officials that have been effecting illegal evictions will also be penalized. Then anybody who maliciously or falsely tries to encroach on another person's land will face tough actions by the government, including prosecution and forcing him or her to compensate the victims of his or her malicious and illegal actions. Nobody should encroach on government land, that is the forest reserves, wetlands, government ranches, but also government institutional land. The government will intensify efforts to raise money for its land fund so that the phenomenon of dual ownership of land in Buganda, Ankole, Toro, and Bunyoro is ended. The types of occupancy we have under the law and those that are protected by the law, we have the bona fide occupant. Bona fide occupant means a person who, before coming into the force of the Constitution, that is the Constitution of 1995, had occupied and utilized or developed any land unchallenged by the registered owner or agent of the registered owner for 12 years or more years before coming into force of the 1995 Constitution. B, had been settled on land by government or agent of government, which may include a local authority. To qualify to be a bona fide occupant, one must be settled and utilized, must be settled and utilize the land unchallenged by the registered owner or his agency or her agents for 12 years or more before the coming into force of the Constitution. This is a person who settled and used the land before 8th October 1983. Lawful occupant means a person occupying land by virtue of A, the repealed laws, the Busulu and the Mvujo law of the 1928, Electoral Landlord and Tenant Law of the 1937, and called a Landlord and Tenant Law of 1937. B, a person who entered the land with the consent of the registered owner and includes the purchaser or a person who had occupied the land as a customary tenant, but whose tenancy was not disclosed or compensated for by the registered owner at the time of acquiring registered interest. What the law says about the tenants by occupancy. The security of occupants of tenants, those are the vivanja holders, on registered land is guaranteed by the 1995 Constitution, Article 2378, and the Land Act, Cap 227, Section 92, 1E of the Land Act, also criminalizes any attempt to evict all participation in the eviction of a lawful and a bona fide occupant from registered land without an order of eviction from a competent court of law. A person who attempts to evicts or participates in the eviction of a lawful or bona fide occupant from registered land without an order of eviction commits an offense and is liable on conviction to imprisonment not exceeding 7 years. Any tenant who sells his or her chibanja without giving the first option of buying the chibanja and taking the assignment of the tenancy to the landowner also commits an offense and is liable to imprisonment not exceeding 4 years or a fine of Ugandan shillings 1,920,000 shillings or both, and will forfeit his or her right to the landowner. Where the registered owner gives consent to the tenant by occupants to sell his or her rights of occupancy to the third party, the tenant by occupants must introduce the third party to the landlord. But change in ownership of title effected by the landlord through sales, donation, or as a result of succession does not in any way affect the existing interests of the lawful and bona fide occupants. And the new landlord is obliged to respect the existing interests he or she finds on the land. This means that the registered landowner is free to sell his or her land with or without offering the first option to the tenants by occupancy, but the new landlord cannot evict the existing tenants he or she finds on that land as they become his or her tenants. We are looking at the practice directions on the issue of orders relating to registered land, which affect or impact on the tenants by occupancy, the practice direction number 2007 by the Chief Justice. The practice direction on eviction orders had some of these provisions: that the tenants on the registered land shall be deemed to be tenants of the registered owner, though they may not have their encumbrances registered on the certificate of title. For the judicial officer to determine whether the tenant is a lawful or bona fide occupant, he or she will evaluate the evidence carefully and establish the origin, succession to or acquisition of the tenants by the tenant by occupancy. The judicial officer should visit locus in quo before deciding a land matter likely to affect rights of the tenants by occupants. Judicial officers should take great care when deciding cases where tenants by occupants have not been parties to the suit or have not been given an opportunity to be heard. The Constitution, land evictions, practice directions, again, that were given in 2021, by the Chief Justice further said that every eviction or demolition shall be preceded by a valid court order, properly identifying the persons taking part in the eviction or demolition, and upon presentation of the formal authorizations for the eviction or demolition, the police and local authority of the area shall be notified and shall be present to witness the eviction or demolition. And every eviction or demolition shall be carried out in a manner that respects the dignity, right to life, right to property, right to security of all persons affected. And measures shall be taken to ensure the effective protection of vulnerable persons, including women, children, the elderly, and people with disabilities. In case it can't be achieved, the process must be stopped immediately. And eviction orders are normally carried out between 8 a.m. to 6 p.m. and not on a weekend, not on a public holiday, not on days when courts are having vacation. So those are the things we expect people to follow. And before any demolition takes place, the court orders must be scrutinized by the respective district security committees. And they must also make sure that they visit where the eviction is likely to be carried out to assess, and in case they find out that it's not possible for an eviction to be done in the right way without violating the rights, then they must report to the authorities that gave out that court order that it's not possible to be done on ground. We have put in place measures to mitigate fraud in the processes of special certificates of titles. You have seen cases where the ministry is giving out special certificates of titles, and people have been complaining at times that they don't get information because the law provides that such special certificates notices must be put in the Gazette. But as a ministry, we are now intensifying on our measures to reduce on the fraud associated with the special certificates. Section 70 of the Registration of Titles Act gives the right to anyone who has custody of a certificate and knows the circumstances surrounding the loss to apply for a special certificate of title. Although a registered proprietor is entitled to title replacement, loss of a certificate is not an ordinary phenomenon. Hence the need for extra administrative measures in addition to the Gazette to mitigate the latest fraud trends we are experiencing. The section has been abused, resulting into fraud related, such as application of special titles on mortgaged properties. Somebody already put a title in a bank, but now for other reasons, they come to the offices and report that their titles got lost. And thereafter, the registered proprietors claim stolen titles in order to defeat bank interests. Where there is lack of clarity on the above, legal procedures, land officers and registrars should refer back the files for clarification. By prioritizing land inspections, we will together enhance the credibility and transparency of our registration process and safeguard the property rights of all the stakeholders in Uganda. The role of LCs in land matters, as I conclude.